Since Sisu Legal is a cross-border immigration firm, it's time to compare the impact of criminality on immigration law in Canada versus the US. The concept of inadmissibility under US immigration law is actually very similar to Canada. Individuals who are inadmissible are not permitted by law to enter or remain in the US. In the US, the Immigration and Nationality Act sets out the grounds for inadmissibility, which includes health, criminal activity, national security, public charge, fraud and misrepresentation, prior removals, unlawful presence, and some miscellaneous categories. Although the concept of inadmissibility is similar to Canada, the way criminal inadmissibility is determined is different. In Canada, foreign nationals and permanent residents are inadmissible due to serious criminality. The easiest way to distinguish general criminality from serious criminality is by looking at what the possible potential prison sentence would be if the crime were committed in Canada. If the crime carries a potential maximum prison sentence of less than 10 years, it's considered general criminality. Note that foreign nationals can be found inadmissible for general criminality, but not PRs. Serious criminality attaches to those crimes that are punishable by a prison sentence of 10 years or more. Criminal inadmissibility in the US really doesn't focus so much on the prison sentence. The focus is actually on the crimes themselves. There are approximately 10 grounds for inadmissibility due to criminal reasons, but this video is just going to focus on the grounds that we see in our office the most. First, crimes involving moral turpitude. What's that even mean? It's not defined by statute, but US common law has defined it generally as an act that is inherently base, vile, or depraved, and contrary to the accepted rules of morality and the duties owed between persons or to society in general. This is a category to label a crime and does not define the crime itself, meaning the Board of Immigration Appeals can technically assign the moral turpitude designation to any crime it wants. Some of the more common crimes, though, that moral turpitude attaches to includes things like murder, rape, child abuse, felony hit and run, and aggravated assault. Since criminal convictions in the US are usually handled on a state-by-state basis, unless the crime crosses state lines or is a federal offense, what constitutes moral turpitude may vary from state to state as well. The second ground for US criminal inadmissibility is violation of any controlled substance law, basically foreign or domestic laws relating to illegal drugs. This is a really good time to pause and to remind you that even though marijuana has been delegalized in several US states, it is still a Schedule I substance under the Federal Controlled Substances Act. Non-citizens who use marijuana or are arrested for marijuana-related crimes could be deemed inadmissible to the United States. The third ground is having multiple criminal convictions. Any person convicted of 2 or more crimes is inadmissible if the person was sentenced to 5 or more total years in prison, counting sentences in the aggregate in this example. This applies regardless of whether the crimes involved moral turpitude or if there were multiple convictions arising from a single trial or event. Next is drug trafficking. If any immigration officer knows or has reason to believe that a person has been involved in the trafficking of controlled substances, that person is inadmissible to the US. Now, has to believe is your clue that this inadmissibility provision has a long reach. In fact, this is one of the most frequently applied inadmissibility provisions. A consular officer often makes this determination based on information available in US government databases, and no statute of limitations applies. Interestingly, consular officers don't solely look at convictions in making this decision. In fact, the government might determine that an arrest, charges, or trafficking-related detention is an indicator of guilt, therefore making the person inadmissible. Often, consular officers won't ask questions or dig further for context, simply because they may rely on what's in the database. This is a significant departure from what we see in Canada. Now, depending on your circumstances and the reason why you need to seek entry to the US, different remedies or waivers may be available to you. Visit our website at www.sisulegal.com to learn more.